Good afternoon, everyone. I'm Patrick Gaspard, the President and CEO of the Center for American Progress. And on behalf of CAP and our extraordinary co-hosts at the Brennan Center for Justice, who work every single day to reform, revitalize, and defend our systems of justice, welcome to today's event. Now I'm thrilled to welcome the incredible Laura Coates, a senior legal analyst at CNN, who will be moderating today's discussion. She'll be speaking with Sherilyn Ifill and Michael Waldman, brilliant and bold leaders on constitutional law, who both, central to today's discussion, served as distinguished members of last year's Presidential Commission on the Supreme Court. I'll turn it over to Laura in just a moment, but before I do, let me lay out the landscape for this urgent convening. Our institutional tentpoles of democracy are all suffering from a crisis of legitimacy. Tragically, that's long been true of government, where popular vote majorities yield to political structures that advantage radical minorities. It's increasingly seen to be the case with our media in this communications revolution where no central facts can hold the square. And now, our highest court has been exposed and implicated in this legitimacy crisis as a conservative majority appointed through manipulations of parliamentary tools wields the Constitution as a bulwark for only rights, quote, deeply rooted in the nation's history and tradition. Ironies and contradictions abound. Precedent and principles have been ripped to shreds in the nomination process, which now has consequences in rulings that are decades out of step with established law and with the widespread sentiments of the majority of Americans. It's a kind of zombification of the law. That's why President Biden established a commission to offer analysis on possible reforms. And it's become clear just how prescient that decision was. But it's also clear that we have not had a public discussion of those findings. And now I think is the urgent opportunity to do so, because our courts are indeed in crisis. Millions are losing access to abortion as we speak, with trigger laws and bans coming into play now that Roe versus Wade has been struck down. A 100-year-old gun law in New York has been cast aside, with the court essentially ruling that guns have more rights than women, while at the same time, the court has gutted a major tool in the administration's arsenal to keep our air clean and communities safe. The court has already announced that it will hear blockbuster cases related to affirmative action, voting rights, and the power that state legislatures have over election laws. This extreme Supreme Court majority is marching us steadily back towards a cruel and indifferent past. So where does that leave us? This appalling misuse of power requires a swift and unprecedented response. It's time we outmatch the level of impropriety with robust reforms that can both depoliticize and re-legitimize the court and chart a path forward. That's where the findings and learnings of the President's Commission on the Supreme Court come into play. As we seek a steadfast, nonpartisan court system from top to bottom, Sherilyn and Michael offer a unique insight into the most effective and viable solutions going forward, with clear eyes on the vulnerabilities of an institution that has been dangerously co-opted. And let me just say, Michael and Sherilyn's leadership in this space goes back a ways. From Michael's book on the fight to vote, which explores the through line of voting in America, and among other things, examines the Supreme Court's role in shaping that right, to Sherilyn's role as a litigator, scholar, and president for a civil rights organization that has worked on so many of the issues now coming before the court. I am hugely honored that we're hosting two giants in the fight for a more equitable, more accountable America, and thrilled that we have such an accomplished host and legal analyst to shape our conversation as well. Before working as a CNN anchor and legal analyst, Laura served in the Department of Justice as a federal prosecutor. She worked as a trial attorney in the Civil Rights Division during both the Bush and Obama administrations, and she specialized in the enforcement of voting rights throughout the country. She's also served as an assistant U.S. attorney for the District of Columbia and is the author of two books, her latest called Just Pursuit, A Black Prosecutor's Fight for Fairness, which came out earlier this year. Laura, thank you for joining us. We're now in your good and capable hands.
Wow, I'm so thrilled to be here. And thank you, Patrick, for having me here and for this really incredible panel. What a powerful discussion we are about to have. I encourage all of you to carry on the conversation online and use the hashtag CAP events as well as part of it. You can also see part of the reports we're going to talk about and mention throughout our conversation today. If you look at the chat messages you see on your screen, there's a way for us to engage and for you to be a part of the conversation out there as well. We're going to take audience questions towards the end of our program, so you'll be able to pick the brains of our esteemed colleagues as well. And so Sherilyn and Michael, I invite both of you all to join the conversation and to be seen by everyone who's hoping to hear and glean from all that you have done. You know, it would really take us, as you both can imagine, and you're so humbled you won't admit it, all day to really thoroughly tap into the breadth of your experience. So I'm going to ask you all to read up on our guests as well and get more information. And I want to dive right in to our conversation. And, you know, Michael, Sherilyn, you both were instrumental and a part of the Presidential Commission on discussions surrounding reforming these courts. And we remember all too well conversations during the last campaign about things from the statements, the phrasing of court packing, to discussions around public trust and perceptions of the political or apolitical nature of the courts. We've had discussions around the co-equal branch of government and the checks and balances. But as you know, from the commission, not everything that was highlighted or came of it was truly adopted, was truly a part of what we see right now when we think about our court systems. I'd love to get a sense from both of you, an insider's perspective, on what do you think ought to have been or were the big takeaways, either from your experience with this commission or what you think should not have been left on the table. Let me begin with you, Sherilyn.
Thanks so much, Laura. So I would say, first of all, that Michael and I were I think, the only two members of the commission who were not full-time scholars. You know, we both led organizations. Michael still leads the Brennan Center. I, at that time, was president and director counsel of the NAACP Legal Defense Fund, an organization I've led for 10 years, but and from which I stepped down several months ago. And that was tricky because we both litigate. LDF obviously has a very storied reputation over its 82-year history of litigating before the Supreme Court. And so, you know, it was a bit tricky for us, certainly. But I think it's important to remember a few things. Number one, from the outset, the president made it clear in his commission that the commission would not make recommendations to him about court expansion. And no matter how many times he said it, no matter how many times the commission said it, that's what people thought the commission was about, right? So it was set up to be a disappointment from the beginning because that's what people wanted to hear. And I understand, because that was the issue of the day. So just first of all, that was not the charge to recommend, you know, court expansion or not court expansion. The reason I was willing to join, and Michael can speak for himself, there are really two reasons. One is I've been writing about judges since I became a scholar, since I left LDF as a baby lawyer in 1993 and started writing. And one of the areas that I've written a great deal about, a number of law review articles, you know, is about the Supreme Court and particularly ethics and recusal. And so I thought it was important that the commission expand the conversation to other areas of Supreme Court practice, which it did, and for which I think it deserves credit in really digging into some of the other areas that we think are important and go to this question of legitimacy. The second reason, and really the primary reason that I wanted to join, is because I believe that civil rights litigators, particularly those who have a Supreme Court practice, as LDF does and other civil rights organizations do, have an actually unique perspective on some of the issues that I think otherwise don't get fully aired or get aired in a skewed manner. The best example of this is the shadow docket. And we can talk about this more later in the conversation, but I thought it was very important to infuse the conversation about what is wrong at this moment with that practice and with those procedures and the way the court is approaching the shadow docket from the perspective of civil rights litigators. And so I wanted to bring that perspective into the deliberations that otherwise I think would not have had a vigorous opportunity to see those issues through that lens.
Well, I mean, Michael, I mean, what you described too, Sherilyn, is the idea of practitioners. I mean, imagine that. Imagine that people who actually will know what they're talking about in real terms and be able to say, here's what I've actually experienced. There is an unquestionable value in having that perspective and having that viewpoint, infusing an otherwise, well, that can be a very largely esoteric discussion about how we think the court should be, how we think the founding fathers envisioned the checks and balances. It really is incumbent upon the commission, and of course, overall, our discussions here today and too. And when you speak to that, Michael, the idea of balancing who has a seat at the table and why that matters in these overall discussions.
Well, thank you so much, Laura. And it was a privilege to be on the commission with Sherilyn Ifill and on this conversation as well. She's right. It was the total of 36 people on the commission, 34 of whom were full-time law professors. For me, it was sort of like an anxiety dream post-law school. Was
the entire thing Socratic? Were they calling on you guys at different points in time?
I had to hide my ignorance as best I could. You know, we know that when a commission is appointed, very often the purpose of a commission is to make sure that nothing happens. That's certainly true in government as a general matter. I think there were some pretty interesting and important things that came out of this, though. And think about the fact that this was a year or so ago that these commission meetings were happening, and how much has happened in our understanding of this Supreme Court, of the Supreme Court, of its impact and of its radicalism since then. First, I think two things when you read the very, very well done report and think about what the topics were it was talking about. First was, to me, it was important to make clear that the Supreme Court is not a religious institution. It wants to do its work with these sort of puffs of smoke coming out in oracular silence, but that it's a political institution, that we as Americans have been fighting about the Supreme Court from the beginning of the country's history, and that is actually entirely appropriate. It is not a breach of norms to talk about the Supreme Court, whether it ought to be expanded, whether it's veering off course. One fact that is in the commission's report is that just as one political matter, this is a factual, not a partisan statement, one party, the Democrats, have won the popular vote in 7 of the last 8 presidential elections. That's the longest such winning streak in the country's history. But the other party has appointed 6 of the 9 Supreme Court justices. And in fact, the last time the Republican nominees have had a majority of the Supreme Court since 1970, even as the country has certainly had divided government mostly since then. So understanding and having these law professors talk about the political nature of the court, I thought was important too. The other thing that was interesting and important, I think, actually came to me during the public hearings. There were a lot of really important testimonies given on a whole bunch of different topics with a lot of different philosophical approaches. But one thing that was quite striking was witnesses from the left, witnesses from the center, witnesses from the right. They might disagree on court expansion, on this thing or that thing. They all said, oh, but I support term limits. There is a real nascent consensus in our country to limit the terms of Supreme Court justices. And that is an idea that is not new, but is really important. And I came away struck by the force of that idea out in the country.
Let's dive into that, because of course, when you think about the political aspects, and again, it's as much as public perception should not rule the day in every category of our lives, when we're talking about the courts, the buck stops there, and there is gravitas assigned and weight that is given to those opinions because we believe that they should be the final word. And if they're not viewed in a legitimate fashion, you're going to have many end runs around or just complete dismissal of what they have to say. And you can look at Texas most recently last summer, prior to the overturning of Roe v. Wade through Dobbs, where many were stunned despite, forget the actual substantive nature of the law in Texas and what the category of information they were talking about. But the fact that they were able to do an end run around precedent, and the Supreme Court said, Okay, knowing they had an active case they had yet to decide at that time allowed them to essentially get a pass. That, for many, was the beginning of a conversation around, well, then if you don't necessarily value your precedent, then how can the common person and the states and everyday people do so? And it comes down to the idea of that transition of power you guys think about. So let's dive into the idea of term limits in particular. And I'm wondering, Sherilyn, when you think about this, and both of you I invite to join in, when you think about term limits, is that giving in to a perception that the court is no longer apolitical, or that it's not viewed as an apolitical body? Because term limits are there in its essence to be able to have judges not be beholden to the whims of elections. And be able to just have a steadfast approach that can continue. And the theory is you're not going to have to be bothered by politics if you don't have a term limit. If you have term limits, does that disrupt that in a way that hurts our courts?
So I don't think necessarily. I mean, I would say, first of all, it's a little strange for me to start the conversation at term limits, because of course term limits would require a constitutional amendment. Lifetime tenure is in the Constitution. And we talked about that in the report, that is, kind of in many ways, the most difficult of the various, structural reforms that could be considered, because it would require a constitutional amendment. So we should begin there to just recognize that. Secondly, I don't think that term limits necessarily imperil. I think there are some very fascinating ideas about 18-year terms and so forth, and who gets added and who gets, and I don't want to get into the details of, any of those proposals. I want to meet your question right where it is, which is, is it appropriate to talk about this now, or does it give in to an idea that, the public is clamoring for change and so we have to change? And if so, will it weaken in some ways, the legitimacy or the impartiality of the court? And I think those actually, Laura, are precisely the questions that we should be asking. On the first question, this is the part that I think, and there was some tussle on the commission about this, about how the work would be perceived. And I can only say in the strongest terms, and I actually said this at a public hearing, that the Supreme Court sits within our democracy, not outside of it and over it. The idea that to critique policies and practices of the Supreme Court, or even the size of the Supreme Court, or the actions of the Supreme Court, somehow itself undermines or questions the legitimacy of the court, for me is really troubling. And it speaks to the point that I think in your introduction, you were talking about this, Laura. The idea that, the Supreme Court has, and Michael alluded to it as well, has achieved this mythic status. And, I'm not even against the idea of us revering our highest court. I'm kind of a sucker for that kind of thing. But I would say two things about that. Number one, that doesn't mean that things can't change about it. It's in the democracy. Even the number of justices has not always been 9. Congress has a tremendous amount of power over the Supreme Court, much of which it does not exercise, but could. And it has from time to time. It can expand and retract the jurisdiction of the court. It can make all kinds of rules associated with the court, right? And that is within the constitutional structure. So that's not verboten. It's not verboten to talk about it, to be serious about it, to make proposals about it, and where necessary for Congress to take action. So that's the first thing, is that we're not having some weird, inappropriate conversation. In a democracy, this is what we're supposed to do. When we see things that are wrong in the executive branch, when John Kennedy had his brother as his attorney general, we created nepotism rules because, as much as many people love John Kennedy, that was kind of icky, right? For many people. And we thought, well, there ought to be, we're supposed to correct things that we see are wrong. The conversation we're having about filibuster rules in Congress, right? We are supposed to be able to correct issues that we see stand in the way of our democracy being able to be as true to itself as it could possibly be. So this is an appropriate conversation for us to be having, and term limits is an appropriate conversation. As I said, it's starting at the hardest part of the conversation because it would require a constitutional amendment. So that's difficult. And what that sometimes does is it shuts down all of these other things, the way in which the shadow docket is managed, the fact that the Supreme Court is not, doesn't have an ethics code that it is required to be bound by, the fact that the recusal practice is all over the place, and that we can't tell what's happening in the black box, and that each judge just makes their own decision and there's no check on it. That, financial disclosures, however the Supreme Court does it, they do it, and there's no kind of accountability. There are all these other things that go to the questions of legitimacy that are very much what the public is contending with at this moment. And you raised this as well earlier, Laura, the confirmation process itself, right?
I want to
money in that process, and what are the relevant issues that we should be discussing. So to me, there's a big set of things that are actually doable and important, but it all begins with the idea that this conversation is exactly the conversation we should be having if we're being true to our democracy, because the Supreme Court, it may be the highest democratic structure, but it is a democratic structure within a democracy that we have the right to really grapple with and be prepared to change when necessary.
I think that's so important. I think about, as you were speaking, that James Baldwin quote about, I love this country like no other, and for that reason, I reserve the right to perpetually criticize it. And that's sort of the idea within the democratic structure. And it strikes me as she's speaking, Michael, I'd love you to your take on that, but also it strikes me as we're talking about court reform, maybe because of the mythical oversized or outsized role that we believe the Supreme Court has and also has played, they only really decide about 75 cases a year. I mean, most of the time we're talking about the courts in America, we're talking about the so-called lower courts. And yeah, they're not the judicial 9, but many would say, an appellate court, circuit court, a district court, let alone any other court, they're not really lowly courts, although they are lower courts. So should the conversation be more expansive in thinking about not just what's happening within the Supreme Court of the United States, but the courts, the volume of courts, the breadth of courts that are going to decide most of the matters in this country?
Well, yes, and we all worked very hard to keep that issue away from this commission, because Congress does not need a commission to tell it that they should expand the number of judges in the federal court system. The last time that happened was in 1990. I think there's about 100 million more people in the country than there were then, and it makes sense to expand the number of lower court judgeships and appeals court judgeships. And among other things, among the benefits that would come from that would be a significant opportunity to improve diversity in who sits on the federal bench, which continuously lags behind the country we all live in. That is the kind of thing that also doesn't really necessarily have a partisan valence. I believe Chief Justice Roberts, for example, has urged expansion of the courts. It's a functional thing. They would work better, and people seeking justice, businesses suing each other, whoever uses those federal courts, immigrants seeking appeals of their rulings, they all need a federal court system that is open and workable. I so agree with what Sherilyn said about understanding the court is an institution in our democracy. And like all those institutions, whether it's the presidency or Congress or anything else, it has to earn that legitimacy. It has to earn that reverence. And that's especially true in some ways for the courts, which if you look at the Constitution, they got a few hundred words, about 1/10 of the amount of attention given to the Congress and to the presidency. The framers expected that those democratically accountable branches would be making social policy in our country. Even though many of them did support judicial review, the degree to which, with our political system paralyzed in a lot of ways, the degree to which the Supreme Court has taken on itself the act of being a super legislature. And this term in particular, I'm writing a book about this term called the supermajority, and it almost reads like fiction. You had among the people harshly criticizing the Supreme Court and its operations were the justices themselves, not only in their rulings or dissents, but they started giving speeches this year attacking each other, and making clear that a lot of the issues, such as the shadow docket, which people may not realize what that refers to, is when there's a major topic. Sometimes there are emergency rulings that have to be made. But what we saw this year in the Texas abortion law, we were all sitting around waiting to see, would they go all the way? Would they overrule Roe versus Wade in the Dobbs case? Would they say the magic words? Would that trigger a response, a backlash, a social movement in the way that Roe v. Wade did too? And meanwhile, Texas banned abortion and the Supreme Court just let it happen. and didn't issue a full ruling on it. And made clear.
Just to be clear, Michael, so everyone knows, when you're talking about a shadow docket, that means that they don't have to go through the full hearing process in a public fashion where they're issuing opinions. We come to know about how they're done. Is that the concern you're talking about?
It's emergency orders, so I want to make sure that they should go through. The implication of emergency orders is that it's supposed to be an order that holds the status quo while the litigation process happens, and it actually is connected to the conversation you two were having about the lower courts, which are increasingly becoming potted plants in our system because they can have full trials and have decisions that are 200 pages, and many states know they can just go right to the Supreme Court, and on the shadow docket they can undo what has happened in the lower courts without there being oral argument, full appellate review, full briefing, and so forth. So it's an emergency order, which you can understand, for example, in the death penalty context, in which there needs to be an emergency order, or in which a state goes to the Supreme Court and says, we need to stop this because this is, we need the status quo to be held. But when the court increasingly expands the kinds of cases that they are essentially deciding, right? It's because it's not like, oh, we're going to have a trial later. You only have a certain amount of time in which you can get an abortion, right? So obviously, if you are a Texan, the most populous state in the country, and you can't get an abortion because of the Texas law, the fact that there's going to be a trial next year about whether the law it's constitutional and then it's going to go up through the Court of Appeals doesn't help you, right? If you don't have access to the ballot and the election is in 6 months, the fact that next year there would be a trial and then it would go on appeal, that doesn't help you, right? If there's a discriminatory redistricting map, as there is in Louisiana and in Alabama, and the district court finds them to be racially discriminatory, and it's upheld on appeal, and there should be an additional Black district in each one of those congressional maps, and the Supreme Court stays the decision below, it means that in that election this year, those old maps that have been found discriminatory will be the maps on which there is an election this year. You can't get that back.
So that's the problem. But then, Michael, what is the guardrail or solution then? I mean, you're talking about the issues of the shadow docket and the expansion of it and the reality of it. What are we to do about it? You're talking about court reform. That seems like an area, as she's articulating, you both expanded upon, is ripe for reform and opportunity. Is that possible?
Well, there are some things that could be done legislatively. Congress has tremendous power to make rules about how appeals happen or what jurisdiction the Supreme Court has. That is also the kind of thing that has to be done within the court. And it is hard to have this conversation outside the context of what this current Supreme Court has revealed itself to be. We've lived, certainly throughout much of American history, the Supreme Court has been a small c conservative body, protecting property above all else. And we know that in the last decade or so, the Roberts Court, on a lot of 5-4 rulings on issues that Sherilyn and I care deeply about around our democracy, around racial justice, has been a particularly destructive force, from Citizens United to Shelby County to the Brnovich case on the Voting Rights Act. But now this 6-3 court turns out to be far more aggressive than what had come before, and very much enthralled to a very particular ideological approach toward a very, very, I would argue, extreme notion of how cases should be decided, of originalism. And we saw in the last few days of the term, in last month, a decade's worth of right-wing social change jammed into 3 days by the unelected part of the government, in the Bruen case on the Second Amendment, in the Dobbs case on the right to an abortion, and in the West Virginia versus EPA case, which is the leading edge of trying to gut the regulatory state and its ability to protect the environment and public safety. So all the guardrails we now know need to try to contain a giant truck with the brakes cut rumbling down the road.
Well, they will argue, I'm not speaking for the Supreme Court by any stretch of the imagination, but I would assume their retort would be, no, we're not trying to be judicial activists. We're trying to allow the states to be able to decide for themselves what happens. In the Dobbs case, for example, we're trying to reverse judicial activism in the past by righting this ship. Chip, it is difficult to buy that philosophy personally, because obviously we were trained as lawyers and thinking about how this all works, that there's the balancing interest, the sort of legal way of saying your rights end where mine begin, but now the you and the mine is actually the state's versus the individual privacy interests of people. But I'm wondering, in this new sort of order of things, of saying, oh, I'm returning to the states, are we seeing judicial activism under the guise of a judicial philosophy? Are people hiding behind that notion of originalism or historical, perspectives, or thinking about the textual aspects of it? Is that sort of the beard?
Well, when you decide that originalism is the way, you basically cook the books, right? So I mean, we have to say this as a civil rights lawyer, right? You cook the books on the rights of women. You cook the rights, the books on the rights of racial minorities. Like we understand, right, that there has been an evolution within this country of rights and of citizenship and of standing in public life, among a whole variety of groups. So first of all, you cook the books. Second of all, even if that's your ideology, what should make this all kind of work in a way that's acceptable is process. And that's why the stare decisis piece becomes so tricky, right? Because stare decisis is not something that Michael or I made up. Like, civil rights lawyers didn't make up stare decisis. That principle, right, is a mainstream, small c, conservative principle, right, of judicial decision making, that there have to be a set of reasons and a set of benchmarks before you overrule a decision that you have made in the past, especially a long-standing decision that millions of people have relied on. When you blow past the process, then you can't say, well, it's original. You can't have it both ways, both substance and process, right? Because we're going to disagree on the substance. But the process is the part, Robert Cover, that famous line that Robert Cover said, procedure is the blindfold of justice. I taught civil procedure for 20 years, and I genuinely believe that. They're the rules of the game by which we play. And so regardless of what we believe, we both have to play by the same rules. Now the Supreme Court up and announces, did we say stare decisis? What? Well, no, actually, you don't have to hit all these benchmarks. Stare decisis just means you overturn an earlier decision. And we're all happy that we overturned Plessy versus Ferguson in Brown versus Board of Education. This is just like that, but it's not actually just like that, because Plessy versus Ferguson was overturned after a long process of cases in which the court itself began to wear away at the doctrine of separate but equal, and in which there was a careful calibration of changes in society, of what it actually meant. There was an originalist argument. There is a 14th Amendment originalist argument to overturn Plessy, and so on and so forth. That's not what happened in this case. As many times as abortion has come before the Supreme Court since 1973, Roe has always been upheld. It has been upheld consistently, more times than Plessy was ever upheld in cases before the Supreme Court up until this year. So that kind of reversal is contrary to the principles that this court, these individual justices have described themselves as principles they would adhere to. We've all seen the various confirmation, clips of the various justices saying, Roe is settled law, and we would treat it like settled law, right? Again, settled law, these are not terms that Michael and I created. These are terms that were created by the small c conservative court, and that many of these justices announced themselves to embrace. And so when you just throw them to the wind, then we actually have a right to question the legitimacy of your actions and the legitimacy of the ultimate decision, because you have now eschewed both substance and process. I don't know, Michael, whether you agree with that, because the Plessy thing has been driving me bananas.
Well, it gets cited over and over and over again as, well, we can reverse this because Plessy was overturned and was bad. And therefore, anything we want to overturn because we feel like it, that must be like Plessy v. Ferguson. And so we're morally justified in doing so. The way they made their arguments in the Dobbs case, in the Bruin Second Amendment case, and in the EPA case, to me suggests that there's not a lot of genuine seriousness to this as a philosophical approach, in the sense that, among other things, and this is where the stare decisis point comes in, there is no, quote, history and tradition of relying on brute originalism to make Supreme Court decisions. That is not how our system has evolved over 2 centuries. And in the Second Amendment case, Justice Clarence Thomas, I think it was fake originalism, because there is, in fact, a very long history in the country, including in the founding era, of restrictions and even bans on carrying dangerous weapons. So he kind of skips around and jumps around. And he says, well, this one doesn't count. Well, this was a little bit after the Second Amendment, so that doesn't count. Well, they didn't do it before the Second Amendment, to cherry pick and find in the most tendentious way historical examples. And then he stops in 1868 and never examines why New York State, over a century ago, with 6 other states, passed the law that they struck down. That seems to me like a fairly long time ago, and that's also part of the history and tradition of the country. Then you've got the Dobbs case, and there the originalism to me is terrifying, because, as Sherilyn said, and as so many people know in their gut, it basically says that unless a right is deeply rooted in the country's history and tradition, then unless it is specifically spelled out in the Constitution, courts cannot uphold it. And that means that unless the white men before 1868 who ran the country and ran the Supreme Court and the government, unless they thought it was a right, really genuinely, you can't protect that right at a time when women were not citizens, could not sit on juries, could not own property in so many ways, when Black people were slaves. It is a genuine turning back of the clock. And then there's the third case, the EPA case, where there was no textualism or originalism. They just made it up. They have this original major questions doctrine, which basically said, well, climate change is a really big deal. And so therefore the EPA can't do it without Congress. And as Justice Kagan pointed out in her dissent, the phrase major questions doctrine had never appeared before in a Supreme Court decision. So they chose each different way to undermine their own premises in these major cases. It seemed as if the outcome was what they wanted, and they worked backward from that rather than forward from principle.
Let's add to it how they did it.
Excuse me 1 second. I want to make sure we get some questions in too from the audience. I want to just flag them that they're coming in, and we're going to be delving in deeper. As the audience has given us a lot of food for thought, and I'm going to address those as well. But I want you to hone in on the point that both of you are sort of not tiptoeing around, but the notion of, look, one of the things the court decided to do was be selective and suggest that these rules are only going to apply to this case. Although they've changed the philosophy, as you both have described, talking about the Dobbs case in particular, the idea that here's how we're going to approach something about fundamental rights, but don't worry, it's not going to slide into other things that have the very same foundational, holding and viewpoint. When that sort of thing happens, I mean, it seems to me to be very out of the court's control at that point to be able to keep that set in stone, that they want to limit the way in which a particular judicial approach is then manifested in other ways. And we've seen, have we not, Sherilyn and Michael, over the course of history, that when the Supreme Court issues a ruling, it obviously is supposed to be the final say, but it's interpreted in a variety of ways to test, to try to go back, to try to figure out the constraints and parameters, and it's massaged more often than it's heated. If that's the case, I mean, is the court setting themselves up for the failure of what Alito seemingly, I don't know his mind in this issue, but or intent, but seemingly hoped to be the case, as it would be confined to the issues of abortion? Is that completely naive, or was it strategic?
I think we have the right to question the sincerity, shall we say, of that statement by Justice Alito. I mean, first of all, Justice Thomas's concurrence, which says, bring it on, that this case compels us to review our decision making in the area of same-sex marriage and of what was his other? He left out loving, he left out interracial marriage, but he added Griswold, right? The right to for married couples to obtain contraception.
And Lawrence v. Texas also.
Yeah, that's Lawrence v. Texas, right? That's right. So it was interesting that you had Alito in the majority saying, no, I mean, us, we just mean this. And you had Thomas saying, no, we've got to go all the way. The reason I can question the sincerity is because the Supreme Court did a bit of this in the Shelby County case. Remember in Shelby County versus Holder in 2013, the case in which the Supreme Court essentially gutted Section 5 of the Voting Rights Act, which required preclearance of new voting changes for certain states and jurisdictions with a history of discrimination in the country. The court was very careful to say, but this is only about Section 5. You know, litigants still have Section 2, which they can use to challenge discriminatory voting laws. Fast forward to last summer and the Brnovich case, in which Justice Alito, I'm not sure about the history and traditions. I'm not sure about major questions. I don't know what doctrine that allows him to do this, but basically rewrites and writes a new test for evaluating cases brought under Section 2 of the Voting Rights Act, despite the fact that for, you know, how many years, 50 years, 60 years, we've been litigating using the test that Congress created to litigate cases under Section 2, the Senate factors. That's what we were all trained. I started this work 30 years ago. That's how we were trained. Alito decided last summer in July that he would write a new test for evaluating Section 2 cases. So I'm inclined not to believe that the court feels itself bound. And once again, you know, to quote Maya Angelou, when people tell you who they are the first time, believe them. I think the actions that the court has taken, and the one piece we haven't talked about, which I think is really important, is these are monumentally fundamental shifts in American society that are being created by these decisions that are highly split on the court. Brown versus Board of Education was a unanimous 9-0 decision. It takes sometimes the work of the court to do something that's going to hold us together. US v. Nixon was a unanimous decision. Cooper versus Aaron, a unanimous decision. But basically, since Bush versus Gore, that 5-4 decision, we have seen this court be willing to take on these kinds of cases and decide these kinds of cases in a monumental way, even though there is a clear split on the court. And that's not to be ignored, because there is a responsibility. Michael said earlier about the legitimacy being earned. There is a responsibility that the court has. And even in the Brown case, remember there's Brown 1 and Brown 2. You know, some of us decry Brown 2, but the court was so concerned about the fundamental change that would be required after Brown that they held in abeyance the how. They told us the what, right? That segregated schools are unconstitutional. But how were they going to be desegregated? The court saved that and decided that the following year and had additional briefing and additional arguments to demonstrate a sense of care and understanding of what a shift they would be. And we see none of that with this court.
I want to get into the questions of the audience, and there are quite a few, and I appreciate that people are wanting to be a part of this really powerful discussion and to tap these two powerful brains that we have here, Michael Waldman and Sherilyn Ifill, who are just so eloquent in being able to describe and be discerning in the ability of what we have to look at for court reform. Let's begin. A couple things, and I'm gonna, there's so many, I'm gonna try to streamline them a little bit, and some people may be sort of combined with the others. Nan Goldberg asked a question about President Biden recently agreeing with Mitch McConnell to nominate an anti-choice federal judge in Kentucky in exchange for Republicans agreeing to stop blocking other judicial nominees. She wonders if you think it was appropriate to do so, and is there any basis to believe that there will be a fulfillment of their end of the bargain when it comes to Republicans agreeing not to disrupt the nominee process? Michael?
Well, you know, I don't know the details of that particular case. The timing was unfortunate. I think there is that kind of horse trading. And I would say that one thing that this White House and this administration has done well is to take seriously the job of nominating judges. They've been aided by the fact that there was filibuster reform as relates to allowing judges to be confirmed and justices to be confirmed without having to go past 60 votes. But they have focused quite a bit on making sure that it's not just the same old people being nominated to the courts. There are many more public defenders. There are many more women of color. There are civil rights lawyers, such as my former colleague, Myrna Perez, who is now on the Second Circuit Court of Appeals. And I think that it may well be that this is something that just required a little bit of legislative grease to keep that going, but I don't know the specifics of that case.
Well, I'm going to bridge together a couple different questions. It comes in part from not only Alex Knopp, and I see here Janet Lenacek, and also Gabe, to name a few, who've been really honing on this issue of term limits in particular. And it seems to be the questions are about, well, if term limits are not necessarily the possibility, would age limits be the sort of next frontier and horizon? And there's also been the idea of one person quoted Professor Akhil Amar saying that others claiming that term limits are not actually required to go through a constitutional amendment because a law could require them to ride circuits, but not sit in active cases, for example. Is there a sort of a way to go around this idea of a constitutional process, and would age limits be a possibility as well?
Well, I think we, I'm pretty strongly against age discrimination. So I the
person asking says they're 66 years old. Just what they wanted to put out there.
No, I understand. For me, if the person can do the job, they can do the job. I do think, however, to the second part, that there are, rather than push up against the age issue, there are opportunities to do precisely what you described, because Congress has so much power in terms of the jurisdiction of the court and so forth, to think about, riding circuits and riding circuit and other ways to. And perhaps combined with an expanded Supreme Court could actually work. Again, all of those things are things that can be and should be, discussed and thought about. And they're not related to, some of the other questions. The court's docket, Laura, you said 75 cases. I think it was 66 this year. The docket has been shrinking like crazy. When I was a young lawyer, the court was taking 150 cases a term, and it has steadily been going down. Do we think they should be taking more cases? If they're so overburdened that they have to manage the emergency orders docket in the way that they do, often without written opinions and so forth, maybe they need more personnel. So I think we haven't really yet had the conversation that is outside the political realm. And that's the difficult part, is that so long as we're talking about this, and many people are, as the Democrats need to be able to nominate more Supreme Court justices, which, is a real political consideration. But so long as the conversation stays there and it doesn't move into what is actually the best structure that we need, given all the things Michael has said, 100 million more people in the country, and the way the shadow docket is being managed, and the court's docket, and so on and so forth, and recusal, and conflicts of interest, and so on and so forth. Those are the reasons, and those are the things that I think will undergird the kind of creative ideas that the questioner is referring to, that many people have been exploring.
I'd be remiss. We've heard the words recusal and ethics and conversations surrounding it. We've seen more than our fair share of reporting around Ginny Thomas, the spouse of Justice Clarence Thomas, has been in the news for a variety of reasons, as have questions about recusal, potentially around January 6th events and beyond. I wonder, in terms of how one can, in many ways, help the public perception of the court. One thing is, we think about judges recusing for even the hints of impropriety. Now, we know the Supreme Court is not beholden to the same lower court rules surrounding certain aspects of recusal and requirements, but they do have a federal law that suggests that if somebody has a financial interest, or there is a spouse, there's a disqualifying notion in some regards. Do you think that this is an untapped area where the Supreme Court, and the idea of not having the accountability and checks and required transparency, or even explanations as to why or when they'll recuse? And I don't want to single out Justice Thomas. There's been other accusations among others who've gotten publishing deals, and then, of course, have decided cases involving that as well. Is that the next place to go? The ideas of ethics and the guidelines to recusal to ensure the court's credibility? Michael?
I think it is certainly one of the places to go in all of these different ways. These are all things where the U.S. Supreme Court is different from other courts in the United States, different from other federal courts, all of whom have to follow ethics rules and have procedures for ensuring that when there's a recusal, which is as we know, is when a judge or justice shouldn't be hearing a case for some reason that they don't. Certainly state courts and state Supreme Courts, which are very important, have these kinds of rules and also have term limits. The only high court in the United States that doesn't have some kind of term limit is the U.S. Supreme Court. I will mention that while it is certainly the case that a constitutional amendment could be the way to do term limits, and maybe the most linear way to do it. There are valid legislative proposals that would say basically that justices would stay as federal judges, but would take senior status, and you could add new justices to go along with that. That I think would be constitutional. That could be done by statute. But all of these ethics issues, certainly as the January 6th hearings unfold, the degree to which Justice Thomas's wife Ginny was engaged with the activities that led to the insurrection and the attempt to undo the democratic election, and he participated in at least one case relating to documents about these investigations. That would have been a very good example where it would have been good to have clarity and some ability under the rules for everybody to know how they can how people can proceed and how the public can get its voice heard on these things. All of these are different ways of making the same point, which is the Supreme Court is an institution, as Sherilyn said, within our democracy. It is not above our Constitution. It is not above our democracy. And everything from ethics rules to how judges and justices rather are appointed and how they are ruling is fair game for very robust commentary, debate, and criticism. And I think that's the way it's been all throughout American history. Whenever a Supreme Court has been unduly activist in some ways or extreme or partisan, there's been a response. There's been a backlash. Those have been some of the major decision points in American history. You can certainly make the argument that we're at a point like that right now. But I think part of the answer for all of us is to keep our focus on making the point about the Supreme Court and not lose sight. I'll mention one other case where they sort of dropped some breadcrumbs. In the Rucho case in 2019, John Roberts and the Supreme Court said that federal courts will not police partisan gerrymandering. They just are going to wash their hands of it. But don't worry, state courts can stop gerrymandering under state constitutions. Well, they've just taken a case, meaning 4 justices at least agreed to take a case that argues that, in fact, only state legislatures have the power to set election rules and to gerrymander to their heart's content, and that state courts and constitutions, among others, have no role. That's the Moore versus Harper case, which could be one of the big ones, and I think a particularly dangerous one in the next term.
Absolutely. That's one we all have to watch, and we'll have one of the new justices as a part of that as well for the next term. And thinking about that as we're going into sort of the year before the 2024 presidential elections. I mean, I wonder the timing of these cases. You just have to sort of wink and nod about it. In the very small time we have left, I'm going to ask both of you to leave me with your particular thoughts about where you think are the biggest priorities for court reform. And while you're thinking of that, we just have time for one more question, and it's one that I'm going to combine from several different people in the audience. So I would, it's as quick of a response we can give would be best. And that is the idea of the First Amendment being used as grounds to appeal the Dobbs decision. Many are asking about this as a possibility. What say both of you?
Well, I'll say what I always say about many of these things. I honestly believe that there is a 14th Amendment argument to be made. And, the 14th Amendment is the most transformative amendment in the Constitution. This is the amendment ratified in 1868. Following is one of the 3 Civil War amendments. 13th Amendment was ended slavery. 15th Amendment protected the right to vote against racial discrimination. But the 14th Amendment is the amendment that guarantees equal protection of laws. And it also grants birthright citizenship. And it also provides for the protection of privileges and immunities. And it also provides for due process. And I think it is rich and quite available to be used in this context. Women cannot be equal citizens of this country if they do not have control over their own bodies, if they are subject to having their bodies and the actions they take with their bodies criminalized in ways that are specific to them. So I actually think the 14th has been unexplored and is really vitally important to bring into this discussion.
Michael, you're nodding along.
I'm nodding along, and it's very well said. And one person who felt that the 14th Amendment and equal protection of the law really was a powerful way to undergird protections for abortion rights and other freedoms was Justice Ginsburg, who, as the majority opinion in Dobbs delighted in pointing out, was very critical of Roe v. Wade because of its reliance on privacy as the basis for it. The Casey case went a lot further toward looking at it through the 14th Amendment, but there's great power in the 14th Amendment. But what we have to all shout from the rooftops is that it cannot be read as just what they thought in 1868. Those broad words were put in there on purpose to serve as a constitutional charter for freedom and equality going forward with new challenges, not just whatever they thought back then. And
lost
we
your
all,
video, Michael.
oh, I don't know how that happened.
We still hear you.
It
There
was
you are.
magic. That was, I didn't even pound the table or hit the mouse or anything. I think one of the things we all need to do is to find our voice in taking on the rhetoric, at least, of the judicial philosophy that's being articulated. When you watch these confirmation hearings, even Justice Jackson having, and the others, the need to avoid setting out a judicial philosophy other than just kind of ritualistically mouthing textualism and originalism, I think, to me, that's a dead end. And I think we need to be very robust about it.
Well, listen, our time sadly is coming to a close. It feels like we just started talking. And of course, it's because I'm just so delighted that both of you have joined and have such insight and expertise. And the audience has been riveted, I would say, by our discussion today. And I'm thankful for that. Leave us with a few points that you both want to make. And I mean, just maybe one or just the two top things that you think are going to be should be the biggest priorities in terms of evaluating the next steps in court reform.
Well, I'll say, first of all, very briefly, that, this is, if you think this last term in the Supreme Court was blockbuster, it was, but there is a lot ahead. Michael has already alluded to the Moore versus Harper case, which would fundamentally upend politics in this country, and to me is the single most powerful threat to democracy on the court's docket for the coming term. Affirmative action is on the docket for the coming term with this court. And again, affirmative action, like Roe, every time it has been challenged since 1979, has been upheld. And so the court's boldness and frankly recklessness with which they dispense with stare decisis in the Dobbs case should give us all pause and concern. There's another case that I think has not received enough attention, and it is Brackeen versus Holland, and it is a challenge to the Indian Child Welfare Act case, which really is a case that lies at the heart of tribal sovereignty. We saw the court at the end of this term scoop out some of tribal sovereignty in terms of prosecutions on reservations, and this matters tremendously to Native Americans and is powerful and important. I think we have to keep this conversation going. We're at a moment of tremendous threat and challenge in this country in all aspects of our political realm, and the courts are one of them. I know they want to be above it. I know Justice Alito thinks people are bullying him when they write about it, but we are not. We are being active, responsible citizens who recognize a problem and who are looking for ways to solve it.
Michael?
I completely agree with what Charlene Eiffel has said. To me, the main lesson is this is not a topic for lawyers. It is not a topic for law professors or for judges. It is a topic for we the people. We all need to understand that how we read the Constitution and the role of the Supreme Court is properly a major political issue. Certainly the folks who for decades have waged the campaign to overturn Roe v. Wade or to have the individual right to gun ownership recognized in the Constitution, they understood that. And we need to understand too that kitchen table advocacy on the Constitution is going to be part of our debate going forward, and that can only lead to better things.
Well, Michael Waldman, Charlene Eiffel, what a real treat to have you all here and to converse with you about your experiences. What a range of issues. Thank you to the audience for being so proactive. I hope we were able to cover a lot of ground here, but fear not, there are many a report and discussion ahead. This issue will not stop here near the conversation. Patrick Gaspard, thank you for having us. And of course, this is jointly from the Center for American Progress and also the Brennan Center. So thank you both collectively for allowing this discussion to take place. Back to you, Patrick.
Thank you so much, Laura, and thank you all for your insights, your intellect, and your integrity. Cheryl and I promise this will be an ongoing discussion, and we'll all be sentinels on the wall with you and Michael, Laura, and citizens who are going to take this from the kitchen table to the courtrooms. Thank you all. That was inspired.
Thank you.